Hi, I'm Stanton Skirjanik, the Communications Manager at Mountain States Legal Foundation, a public interest nonprofit law firm where we fight for the rights of liberty under the Constitution. I'm joined here by David McDonald, one of our longtime attorneys here at Mountain States, and we're going to talk today about a really important decision that came down from the Supreme Court last week. David, thanks for joining me.
Thanks for having me.
What case are we talking about? This Sackett v. EPA, EPA v. Sackett? What case is this? What's it about?
Sackett v. Environmental Protection Agency, Sackett v. EPA. So essentially what this case is about is the Sacketts bought a parcel of land about 20 years ago, decided to start building a home on it, and as one does, they were filling in some of the foundation with gravel and stones. They get a letter from the EPA hitting them with a fine, saying they're in violation of the Clean Water Act for polluting a wetland. They go back to the EPA, say, you sure you got the wrong people? Because I don't see any wetland.
We're not on water here.
Yeah, so essentially the connection the EPA was drawing was, okay, well, your land itself is dry, but 200 feet away across the highway, there's a tributary of a stream that flows. It's not quite, yeah. So it's whatever smaller than a stream is running about 200 feet past their property. This stream empties into, or this tributary empties into a stream, a non-navigable stream, which is important for reasons I'll get to in a second, which then travels into a fully intrastate lake, so a lake that's fully within a single state. And the EPA is saying this qualifies, your land qualifies as a wetland under the Clean Water Act.
So you have the house, dirt, a highway, a tiny little stream, or not even a stream, like a little tiny little thing of water, a tributary, then a stream, which you can't navigate, which means you can't put a boat on, is what I'm hearing.
Yeah, more or less.
And then a lake that's not between states, it's within one state.
Correct.
Okay, so I'm guessing Mountain States did something with this case. What did we do? How did we get involved here?
Yeah, so we joined with a couple of our friends and other organizations. So the Cato Institute. Let's see, I have it in front of me here. Who else joined us? Yeah, so we were joined by a couple of organizations. So the Cato Institute, General Contractors of America, National Federation for Independent Businesses, Washington Legal Foundation, and we filed a brief in the Supreme Court on behalf of the Sacketts. And our brief was talking about judicial deference. So what we were saying is that the court should not defer to the EPA's definition of waters of the United States. So our argument is basically the Congress created the administrative agencies in order to assist them with carrying out Congress's policy, because Congress is directed to set the general direction for the country, but they're not chemists, they're not physicists, they don't know how many parts per million of mercury.
Those 535 politicians don't know the first thing about clean water, unless
I'm sure one or two of them probably do, but
maybe but yeah.
So they delegate the details to the administrative agencies, and that's I don't think many people, even us libertarians, really would disagree all too much with that. But the problem is that the agencies tend to, once they get their authority, they tend to expand it as much as humanly possible. So while Congress gave the EPA authority to regulate waters of the United States, the EPA is, yes. So I guess this may take a little bit of background. So
yeah, just briefly, waters United States, I'm guessing, I'm just going to guess here, of the United States is waters that go between states?
Right. So going all back to our fifth grade civics lessons, is United States is a federal republic. The Constitution grants Congress only a very limited number of powers that it can do. Generally, Congress is not permitted to regulate anything going on that's kind of matter of local concern. They're allowed to regulate things that affect the country as a whole. So foreign policy, one of the things that Congress is allowed to regulate is what's called interstate commerce. So that's why you see things, why we mentioned the non-navigable river, intrastate lake. These are important because Congress doesn't have any authority to regulate fully in-state, fully local things. It can only regulate them to the extent they engage in interstate commerce. So that's why the statute that Congress wrote, the Clean Water Act, states that the EPA will have jurisdiction over navigable waters of the United States, which it then defines in a horrible piece of draftsmanship as the waters of the United States. Never mind that navigable waters was already a term of art that had a definitive meaning in 1972.
Yeah.
Right, but they decided to define it again as waters of the United States. So
Right.
we've spent about the last 50 years arguing over what does waters of the United States mean. The EPA essentially says that every piece of water within the United States counts as waters of the United States. Basically, everything except for swimming pools.
So the Sacketts are saying, first off, we're not on water. We're not a wetland to begin with. And we come in with our amicus brief. We also say, but even if it was potentially wetland, it's certainly not one connected to anything that Congress has the authority to control, not anything that the EPA is allowed to define as a navigable water of the United States.
Right. So like we were arguing that the question is for Congress. Yeah. Now there's question what to what extent Congress is even able to regulate some of this stuff that EPA was claiming. That's a separate issue entirely.
Sure.
But the fact of the matter is, regardless of what you think of federalism in general, what Congress said is navigable waters. Waters of the United States is defined as navigable waters. So this is mean like the Mississippi River, the Erie Canal. This is what we're talking about here. The intercoastal waterway. EPA was saying essentially everything except for residential swimming pools counts as a water of the United States. And not only just all those waters, any land somewhere in the vicinity of these waters counts as a water of the United States because they're able to regulate anything that might affect the waters. So we were saying that courts, you don't take the agency's word on this. This is a major issue. Congress gets to decide what this says. This isn't a question of what should be regulated, what should be the level of government control over clean water. That has nothing to do with this case. What this case is what power did Congress delegate to the unelected bureaucrats? And the Supreme Court was 9-0 on that question. On the question of
wait, this in this era of the Supreme Court being divided, you're saying 9-0 the Supreme Court.
All 9 justices rejected the EPA's position. So this is really a vindication of our argument here, because even the 3 justices who would have found that the EPA does have broad authority, even they didn't think that the EPA should have been deferred to in this case because it was an unreasonable position here. So there's not a single member of the court that thinks the EPA's position that essentially all water in the United States is a water of the United States regulated by the Clean Water Act. No one endorsed that position. It's just a question of, do we use this test that Justice Alito formulated based off of a previous test, or do we accept some sort of different test for determining this? But everyone agrees that the Sacketts win, the EPA loses.
Right, because they're not anywhere on water, and certainly not near navigable water.
Yeah, I think that's there's a line by Clarence Thomas in his concurrence, which once again proving the best Supreme Court justice, is that he says not only is the Sackett's land not the Sackett's land is not water let alone a water of the United States. And I think that encapsulates what the case is really about.
Okay. So it sounds pretty clearly that this is a win for property rights. This is a win for the basic rule of law. Is this a win for anything else?
Yes. I mean, we'll have to see how the EPA and the other agencies try to weasel their way out of this, but at least on a first reading, this is a major win for property rights, a major win for the Constitution, for people who believe in the separation of powers. People support limited government as the Constitution promised to us. This is a vindication of that.
Perfect to hear. David, I really appreciate you explaining this for me and for everyone else. Everyone, thank you so much for listening. I hope you learned a little bit like I did. Stay tuned to our website at mslegal.org, and hopefully we'll have something more in depth and written for you to share with your friends and to get more out of David's extensive understanding of this. Thank you, David. Thank you, everyone. Bye-bye.
Thank you.